The moment Congresswoman Jasmine Crockett walked into the federal courthouse that Tuesday morning, everyone knew something extraordinary was about to happen. The 83-year-old Judge Richard Posner, known for his razor-sharp legal mind and decades of courtroom dominance, sat behind the bench with his usual stern expression. But what happened in the next 30 minutes would leave him speechless and change how America views young political leaders forever. Crockett had been summoned to defend her recent congressional actions in what many called a politically motivated hearing. Critics expected her to crumble under Posner's legendary questioning. They thought her youth and relative inexperience would be no match for one of America's most respected legal minds. They were wrong. Before we dive into this incredible showdown, hit that like button if you're ready to see how a young Congresswoman shocked one of the most powerful judges in America, and don't forget to subscribe so you never miss these amazing political moments that are reshaping our country. The courtroom was packed beyond capacity. Legal experts who had driven from universities across 3 states filled the front rows, their notebooks ready to capture what many expected to be a judicial masterclass. Political reporters from major publications sat shoulder to shoulder, their cameras focused on the bench where Judge Posner would soon make his entrance. Curious law students had arrived hours early to claim spots in the back, knowing they were about to witness legal history unfold. Judge Posner had built his legendary reputation over 40 years of distinguished service, writing over 3,000 judicial opinions that had shaped American jurisprudence and authoring dozens of influential legal books that were required reading in law schools nationwide. His sharp intellect was matched only by his reputation for devastating cross-examinations. Legal veterans still told stories of seasoned attorneys who had entered his courtroom confident and left humbled, their arguments systematically dismantled by his razor-sharp questioning. Facing this judicial giant was Jasmine Crockett, the 33-year-old Congresswoman from Texas, whose meteoric rise had surprised even her supporters. In just 2 years in Congress, she had built a reputation as one of the most formidable debaters in the House, combining legal precision with political passion in ways that left opponents struggling to respond. The tension was immediate and almost suffocating. Posner leaned forward in his chair, his reading glasses perched precisely on his nose, methodically scanning through a thick stack of papers that his clerks had prepared the night before. Every line of his weathered face spoke to decades of judicial authority. His gray suit was immaculate, his tie perfectly knotted, his posture radiating the kind of quiet confidence that came from never losing an intellectual battle in 4 decades on the bench. Crockett stood at the defendant's table across from him, her burgundy blazer crisp and professional, every detail of her appearance carefully chosen to project competence and respect for the court. Her leather briefcase sat beside her, seemingly ordinary but filled with documents that would soon turn the entire hearing upside down. What nobody in the courtroom knew was that she had spent the previous 3 weeks working 18-hour days, surviving on coffee and determination, building what would become one of the most comprehensive legal arguments ever presented by a sitting politician. The gallery held a mixture of legal scholars, political reporters, curious law students, and courthouse regulars who had heard rumors that something significant might happen. Among them sat Professor David Liu from Columbia Law School, who had driven 4 hours specifically to watch what he expected to be Posner dismantling another politician who doesn't understand constitutional law. Also present was veteran legal journalist Amanda Rodriguez, whose coverage of federal court proceedings had earned her national recognition for her ability to explain complex legal concepts to general audiences. In the press section, cameras were carefully positioned to capture both participants. The artists who sketched courtroom proceedings for news organizations had their pencils ready, anticipating the kind of dramatic moments that would illustrate the evening news broadcasts. Several court security officers stood at strategic positions. Though their presence seemed more ceremonial than necessary, this was, after all, a hearing about constitutional interpretation, not a criminal trial. Congresswoman Crockett, Posner began, his voice carrying the weight of decades in federal courts. You're here because your recent actions have raised serious questions about constitutional boundaries. I hope you're prepared to defend yourself, with more than political talking points." The gallery fell silent. Everyone knew Posner's reputation for destroying unprepared advocates. Legal scholars had witnessed him reduce seasoned lawyers to stammering confusion with a few pointed questions. Veteran attorneys still shared stories in bar association meetings about colleagues who had entered his courtroom confident and left questioning their understanding of basic legal principles. His technique was legendary. He would identify the weakest point in an argument within minutes, then methodically expose every flaw until the entire legal theory collapsed. Behind Posner, his law clerk sat with carefully prepared briefs, ready to provide additional citations if needed. These brilliant young lawyers, fresh from the top law schools in the country, had spent days researching precedents that might support their judge's anticipated line of questioning. They had prepared for what they expected would be a straightforward, educational exercise in constitutional boundaries, but Crockett didn't flinch. She stood tall, her posture radiating the kind of quiet confidence that comes from knowing you've done your homework. She looked directly at the judge, her gaze steady and respectful but unafraid, and said something that made everyone in the room sit up straighter. "Your Honor, I'm not here to defend myself. I'm here to educate this court on constitutional law." The audacity of that statement rippled through the courtroom like electricity. Judge Richard Posner had been appointed to the federal bench when Jasmine Crockett was still in elementary school. His legal writings had shaped American jurisprudence for generations. He had clerked for Justice William Brennan, taught at the ECI, University of Chicago Law School, and authored groundbreaking works on economic analysis of law. In legal circles, questioning Posner's understanding of constitutional law was like challenging Einstein on physics. But Jasmine Crockett wasn't intimidated by the setting or the reputation of her opponent. The former civil rights attorney had built her career defending the powerless against powerful institutions, often in courtrooms much less prestigious than this one, but no less consequential for her clients' lives. Born and raised in St. Louis to a middle-class family, she had watched her mother work double shifts as a nurse while pursuing her nursing degree at night, instilling in young Jasmine a work ethic that would later define her legal and political career. Her path to this moment had been anything but conventional. After graduating near the top of her class from law school, she could have joined any major law firm in the country, commanded a six-figure starting salary, and begun the traditional climb toward partnership. Instead, she chose to work for a small civil rights organization in Dallas, representing clients who couldn't afford legal fees but desperately needed legal help. For 8 years, she had fought cases involving police misconduct, employment discrimination, and housing rights violations. Those years in Texas courtrooms had taught her something that many politicians never learn: how to prepare thoroughly for battles where losing meant real consequences for real people. When defending a single mother facing wrongful eviction, Crockett would spend weeks researching every relevant statute, every applicable precedent, every possible argument that might save her client's home. When representing a worker who had been fired for reporting safety violations, she would master every detail of federal labor law that might apply to the case. Her colleagues in Congress had learned not to underestimate her sharp legal mind and fearless approach to confrontation, but even they might have been surprised by the depth of preparation she had undertaken for this hearing. While other politicians relied on staff briefings and talking points, Crockett had spent 3 weeks personally reading every major opinion Judge Posner had written in the past decade. She had cross-referenced his judicial decisions with his academic writings, looking for patterns and contradictions that might be useful in defending her position. The preparation had been exhausting. Night after night, she had worked until the early morning hours in her congressional office, surrounded by stacks of legal opinions, academic journals, and law review articles. Her staff had offered to help with the research, but Crockett insisted on doing the work herself. "If I'm going to debate constitutional law with Richard Posner," she had told her chief of staff, "I need to understand every word of his philosophy better than he does." The stakes couldn't be higher. This wasn't just about Crockett's political career or even her congressional actions. This hearing had become a symbol of generational change in American politics. Could a young black woman from Texas stand toe-to-toe with one of the most respected legal minds in America? Could new voices challenge old power structures and win? The morning had begun with legal analysts on major networks confidently predicting Crockett's defeat. "She's walking into the lion's den," one prominent legal commentator had declared during breakfast television coverage. Judge Posner has 40 years of experience dealing with politicians who think they understand constitutional law better than federal judges. This will be educational, but not for him. Political betting markets had heavily favored Posner entering the hearing. Experienced congressional watchers noted that while Crockett had impressed in House hearings, federal court was an entirely different arena. The formal procedures, the weight of judicial authority, and Posner's legendary preparation would create challenges unlike anything she had faced in the political sphere. Judge Posner adjusted his glasses and leaned back in his chair. At 83, he had seen thousands of lawyers come before his bench. He had watched legal trends come and go, witnessed the evolution of constitutional interpretation, and earned respect from both conservative and liberal legal scholars. His economic approach to legal analysis had influenced countless decisions. He wasn't used to being challenged, especially not by politicians. "Congresswoman," Posner said, his tone sharpening, "this court doesn't need education from elected officials. This court provides education to them. Your recent statements about judicial overreach suggest you don't understand the separation of powers." Crockett smiled slightly, the kind of smile that lawyers develop when they know they're holding the winning hand. She reached into her briefcase and pulled out a thick folder. "Your Honor, may I approach the bench?" The judge nodded, curiosity flickering in his eyes. As Crockett walked forward, her heels clicking on the marble floor, whispers spread through the gallery. Legal reporters leaned forward in their seats. Something was about to happen. "Your Honor," Crockett said, placing the folder on the judge's desk, "I have here 17 of your own judicial opinions from the past decade that support my position on constitutional interpretation. I also have excerpts from your book, How Judges Think That Directly Contradict the Legal Theory Being Used to Question My Actions Today." Judge Posner's eyebrows shot up. In 40 years on the bench, he had rarely seen such preparation from anyone, let alone a politician. He opened the folder and began scanning the documents. His expression changed from skeptical to surprised to something approaching amazement. The courtroom held its breath. Even experienced court watchers had never seen Judge Posner's demeanor shift so dramatically. He was known for his poker face, his ability to maintain judicial composure under any circumstances. But as he read through Crockett's carefully compiled evidence, something extraordinary was happening. Judge Posner spent the next several minutes in complete silence, reading through Crockett's materials with the kind of focused attention he usually reserved for the most complex constitutional cases. The only sounds in the courtroom were the rustle of papers, the occasional shuffle of feet from nervous gallery observers, and the steady clicking of the court stenographer's machine. Legal experts exchanged meaningful glances, their eyebrows raised in amazement. Even veteran court watchers who had seen decades of high-profile hearings had never witnessed anything quite like this. When had anyone ever seen Richard Posner, the man who could cite case law from memory and dissect complex legal arguments in real time, taking this much time to process an argument? His reputation was built on his lightning-quick intellect, his ability to identify legal flaws within seconds of hearing an argument. The extended silence suggested something unprecedented was happening. Behind the judge, his law clerks sat frozen, at their desks, unsure whether to approach with additional materials or simply wait for their boss to process what he was reading. These brilliant young lawyers had worked for Posner for months, had seen him handle the most complex legal challenges with ease, but even they seemed stunned by the thoroughness of Crockett's preparation. In the gallery, law school professors, who had traveled hours to witness what they expected to be a routine judicial education, were frantically taking notes. This wasn't going according to any script they had imagined. Professor Sarah Mitchell from Yale Law School was observed whispering to her colleague, In 25 years of courtroom observation, I've never seen preparation like this from anyone, let alone a politician. Finally, Posner looked up. His expression was different now, more thoughtful, less dismissive. Congresswoman, where did you find these particular citations? I spent the last 3 weeks in the Congressional Law Library, Your Honor. I read every opinion you've written since 2010, cross-referenced them with current constitutional debates, and identified patterns in your judicial philosophy that I believe support my position. A murmur ran through the courtroom. The idea that a sitting Congresswoman had spent weeks studying one judge's entire recent body of work was remarkable. But Crockett wasn't finished. May I direct the court's attention to your 2018 opinion in Henderson versus the State Board of V. Elections, she continued. In that case, you wrote, and I quote, "The Constitution is not a suicide pact, nor is it a document frozen in amber. It must be interpreted in the context of contemporary challenges while maintaining fidelity to its core principles." Judge Posner nodded slowly. He remembered the case, remembered writing those words, but he was beginning to see where Crockett was going with this. Your Honor, that's exactly what I was doing in my congressional statements. I was applying constitutional principles to contemporary challenges. The separation of powers doesn't mean Congress cannot critique judicial decisions that affect our constituents. It means we cannot usurp judicial authority, which I have never attempted to do. The judge was quiet for a moment, then asked, "What about your statement that certain judicial decisions were fundamentally undemocratic? Doesn't that suggest you believe judges should bow to popular will rather than constitutional principle?" This was the moment everyone had been waiting for. Judge Posner had just laid out what many considered the fatal flaw in Crockett's position. The courtroom leaned forward as one, the silence so complete that the whir of the air conditioning system became audible. Legal journalists gripped their pens tighter, knowing they were about to witness either a spectacular collapse or an equally spectacular recovery. How could she possibly defend calling judicial decisions undemocratic when the entire point of federal judges was to be insulated from democratic pressures? This was Constitutional Law 101, the fundamental principle that separated the American system from pure majority rule. Even liberal legal scholars who supported Crockett's broader political positions had privately questioned this particular criticism. In Dow, the gallery, law students who had studied judicial independence in their first-year courses watched with fascination. They knew the textbook answer to Posner's challenge, but they also sensed that something more complex was about to unfold. Professor Liu from Columbia leaned forward in his seat, his notebook ready. He had written extensively about the tension between democratic accountability and judicial independence, and he was curious to see how a practicing politician would navigate these theoretical waters. Crockett's pause before answering seemed to last an eternity, though it was probably no more than 10 seconds. During those seconds, she appeared to be making a calculation. She could provide a standard political response about representing her constituents' concerns, which would be safe but unsatisfying. Or she could take a risk and engage with the deeper, constitutional question that Posner had raised. Her decision would determine not just the outcome of this hearing, but how this moment would be remembered in legal and political circles. But Crockett had anticipated this exact question during her weeks of preparation. She had studied not just Posner's judicial opinions, but his academic writings on democratic theory and judicial legitimacy. She understood that he was testing whether she had thought seriously about the constitutional implications of her criticism, or whether she was simply engaging in political grandstanding without considering the broader systemic effects. But Crockett had anticipated this exact question. She reached into her briefcase again and pulled out another document. Your Honor, may I read from your 2016 lecture at Harvard Law School? Posner nodded, though his expression suggested he wasn't sure where this was going. You said, and I quote, from the published transcript, "Judges who ignore the real-world consequences of their decisions in favor of abstract legal principles are not serving justice, they are serving ideology. A truly conservative judicial philosophy must consider How legal decisions affect actual human lives, not just legal theory. The impact was immediate. Several people in the gallery gasped audibly. Legal reporters began frantically taking notes. Judge Posner's own words were being used to support the very position he was questioning. "Congresswoman," Posner said slowly, "are you suggesting that I support your criticism of judicial decisions?" "I'm suggesting, Your Honor, that your own judicial philosophy supports the idea that elected officials have not just the right, but the duty to point out when judicial decisions are having negative effects on the people we represent. That's not attacking the judiciary. That's participating in the constitutional dialogue between branches of government that you yourself have written about extensively." The courtroom was electric with tension. This wasn't going at all the way anyone had expected. Judge Posner, the man known for his quick wit and devastating cross-examinations, was being systematically outmaneuvered by a congresswoman using his own words and ideas. But Posner wasn't finished. He had spent decades developing his legal theories, and he wasn't going to let them be turned against him without a fight. "Congresswoman, you're taking my words out of context. There's a difference between thoughtful criticism of judicial decisions and the inflammatory rhetoric you've been using. When you call judges out-of-touch elitists, that's not constitutional dialogue. That's political grandstanding." The gallery stirred. This was the counterattack everyone had been waiting for. Judge Posner was pushing back, using his reputation and authority to challenge Crockett's interpretation of his work. Crockett nodded respectfully. "Your Honor, you're absolutely right, and I apologize for any language that was unnecessarily inflammatory. But I would like to direct the court's attention to your 2019 dissent in Morrison versus the Department of Education." She opened another folder, revealing what appeared to be dozens of additional documents. "In that dissent you wrote, when judges become so removed from the practical consequences of their decisions that they prioritize legal aesthetics over human welfare, they risk becoming exactly what the founders feared, an unaccountable aristocracy." Judge Posner's face showed genuine surprise. He remembered writing that dissent, but he hadn't expected anyone to connect it to this hearing. "Your Honor, when I called certain judicial decisions elitist, I was echoing your own concern about judges who have become disconnected from the real-world impact of their rulings. I was trying to remind the judiciary of something you yourself have written about: the importance of staying connected to the human consequences of legal decisions." The silence that followed was deafening. Judge Posner stared at the documents in front of him, then at Crockett, then back at the documents. For perhaps the first time in his judicial career, Richard Posner appeared to be genuinely wrestling with an argument that challenged not just his immediate position, but his understanding of his own judicial philosophy. What happened next shocked everyone in the courtroom, including Jasmine Crockett herself. Judge Richard Posner, the man who had spent 4 decades handing down definitive legal judgments, slowly removed his glasses and set them on the bench in front of him. "Congresswoman Crockett," he said quietly, his voice carrying a different tone than anyone had heard from him that day. "In 40 years on this bench, I have never had my own judicial philosophy explained to me so thoroughly by someone I was supposed to be questioning." The courtroom was dead silent. Legal reporters stopped writing. Gallery observers sat frozen. Even the court stenographer seemed to pause her typing. Judge Posner continued, "You have done something remarkable here today. You have taken my scattered thoughts across dozens of opinions and lectures, organized them into a coherent framework, and used that framework to defend a position that I initially thought was indefensible." He picked up one of the documents from Crockett's folder. "This 2018 opinion you cited, I barely remembered writing it. But you're right. I did argue that constitutional interpretation must adapt to contemporary challenges. And this Harvard lecture." He shook his head slowly. "I said those words, but I hadn't fully considered their implications for how elected officials should interact with judicial decisions." The admission was stunning. Judge Richard Posner, one of America's most influential legal minds, was publicly acknowledging that a 33-year-old Congresswoman had helped him understand his own judicial philosophy more clearly. But Crockett wasn't finished. She had prepared for this moment, and she was going to make the most of it. "Your Honor, may I make one final point?" Posner nodded, now clearly curious to see where she would take this. "You wrote in your 2020 book, The Crisis of the American Legal System, that the greatest threat to American jurisprudence was not political interference, but intellectual isolation. You argued that judges needed to engage more actively with other branches of government, not less." She pulled out what appeared to be the final document from her briefcase. "You wrote, the separation of powers was never meant to create intellectual silos. It was meant to create a system of checks and balances, where each branch could learn from the others." Judge Posner was quiet for a long moment, reading over the passage she had cited. When he looked up, his expression had completely transformed. "Congresswoman, you have just demonstrated exactly what I was talking about in that book. You've engaged with judicial thinking in a way that has enhanced both your understanding and mine. This is precisely the kind of interbranch dialogue that I argued was missing from our current system." The impact of these words rippled through the courtroom like an earthquake. Gallery members began whispering to each other. Legal reporters were frantically texting their editors. Everyone realized they were witnessing something unprecedented. One of America's most respected judges was not just conceding a point to a politician, he was praising her legal analysis. But Judge Posner wasn't done. He leaned forward in his chair and looked directly at Crockett. "I came into this hearing expecting to educate you about constitutional boundaries. Instead, you have educated me about the application of my own judicial theories. That is not something that has happened to me before, and it's not something I expected to happen today." He paused, seeming to choose his words carefully. "Congresswoman Crockett, your preparation for this hearing has been extraordinary. Your analysis of judicial opinions has been thorough and insightful. Your understanding of constitutional principles has been sophisticated and nuanced. But most importantly, you have demonstrated exactly the kind of thoughtful engagement between branches of government that our system needs more of." The courtroom erupted. The careful judicial decorum that had dominated the hearing shattered as gallery members began applauding. Legal reporters rushed from their seats to file breaking news stories. Court clerks exchanged amazed glances. Judge Posner raised his hand for quiet, and the room slowly settled down. "Let me be clear about something," he continued. "This hearing was called to question whether Congresswoman Crockett had overstepped constitutional boundaries in her criticism of judicial decisions. Based on the evidence she has presented today, using legal precedent and judicial philosophy, much of it my own, I find that her statements fall well within the bounds of appropriate interbranch dialogue." He looked down at the pile of documents Crockett had provided. "In fact, I would go further. The kind of thoughtful, precedent-based criticism that Congresswoman Crockett has demonstrated today is exactly what the framers envisioned when they created our system of checks and balances." The admission was complete. Judge Richard Posner, who had entered this hearing to discipline a young Congresswoman, was instead endorsing her approach to constitutional dialogue. "This hearing is concluded," Posner announced, bringing down his gavel with finality. "And Congresswoman, thank you. You have reminded an old judge why he fell in love with the law in the first place." The moment Judge Posner's gavel fell, the courtroom exploded into chaos. Legal reporters rushed to file their stories, gallery members pulled out their phones to capture the historic moment, and court clerks scrambled to process what they had just witnessed. But the real drama was just beginning. As Jasmine Crockett packed her briefcase, legal experts approached her with amazement. Professor Margaret Chen from Georgetown Law School, who had been covering the hearing for legal journals, was overheard saying, "In 30 years of courtroom observation, I have never seen anything like this." She didn't just defend herself. She educated one of the most brilliant legal minds in America. The immediate aftermath was unprecedented. Within an hour of the hearing's conclusion, video clips of Judge Posner's final statements were trending on social media platforms across the country. The hashtag Crockett School's judge began spreading rapidly, with legal scholars, political commentators, and ordinary citizens sharing their amazement at what they had witnessed. Legal Twitter, normally a specialized community of academics and practitioners that rarely attracted mainstream attention, exploded with commentary that reached far beyond the usual legal circles. The platform became a virtual seminar room where some of the brightest legal minds in America debated the implications of what they had just witnessed. Harvard law professor Alan Chen tweeted, "What Jasmine Crockett did today will be taught in constitutional law classes for decades. She demonstrated the highest level of legal scholarship while defending principles of democratic governance." The tweet was shared thousands of times within the first hour, attracting responses from legal scholars across the political spectrum. Professor Jennifer Martinez from Stanford Law School added her own analysis. Crockett's strategy of using Posner's own intellectual evolution to support her position was brilliant legal advocacy. She turned his consistency into her strength, rather than attacking his credibility. The thread that followed included detailed analysis of specific legal citations and their strategic use in the hearing. But the story wasn't just spreading among legal professionals. Political Twitter began picking up the hashtags, with both conservative and liberal commentators trying to understand the broader implications of the hearing. The unusual sight of a federal judge publicly praising a politician's constitutional analysis challenged many people's assumptions about how these institutions typically interact. Major news networks began breaking into regular programming to report on the hearing, struggling to explain to their audiences why this particular legal proceeding was so significant. The unprecedented nature of the outcome, a federal judge publicly acknowledging that a politician had enhanced his understanding of constitutional law, made it impossible for political editors to ignore, even if they weren't sure how to categorize, the story. Network legal analysts were summoned to provide context for viewers who might not understand why Judge Posner's reaction was so extraordinary. This is like watching a Nobel Prize winner in physics thank a high school student for helping them understand their own theories, one commentator explained during an emergency evening broadcast. It just doesn't happen in the legal world. Legal news websites worked frantically to publish comprehensive analyses of Crockett's strategy before their competitors could beat them to print. A major legal publication's website crashed twice from traffic overload as legal professionals tried to access their detailed breakdown of the hearing transcripts. Their piece, titled "How Congresswoman Crockett Used Judge Posner's Own Philosophy to Win Her Case," became the most read legal article of the year within 48 hours of publication. The story captured attention because it challenged fundamental assumptions about expertise and authority in American institutions. Here was a young politician who had out-prepared and out-argued one of the most respected legal minds in the country, using his own work as her foundation. It suggested possibilities for intellectual discourse that most people had assumed were impossible in the current political climate. But the impact went far beyond the legal community. Political leaders from both parties began weighing in on what the hearing meant for American governance. House Judiciary Committee members who had been critical of Crockett's previous statements now found themselves in an awkward position. Several issued statements acknowledging that perhaps her approach to judicial criticism had been more sophisticated than they had initially understood. The response wasn't universally positive, of course. Some conservative legal scholars argued that Judge Posner had been too generous in his assessment, that political criticism of judicial decisions remained inappropriate regardless of how well-researched it was. But even these critics had to acknowledge the extraordinary level of preparation and legal knowledge that Crockett had demonstrated. Perhaps most significantly, law schools across the country began incorporating the hearing into their curricula. Constitutional law professors saw it as a perfect example of how different branches of government could engage in productive dialogue about legal principles. Trial advocacy instructors used Crockett's preparation and argument strategy as a model for their students. The hearing also sparked broader conversations about generational change in American politics and the evolving role of expertise in democratic institutions. Political commentators across the spectrum began analyzing what the Posner-Crockett exchange revealed about the changing nature of political discourse in America. Conservative commentators noted that Crockett had engaged with judicial philosophy on its own terms rather than simply attacking judges as partisan actors. Liberal commentators pointed to her success as evidence that younger politicians could combine progressive values with serious intellectual rigor. Academic conferences scheduled panels specifically to discuss the hearing and its implications for American governance. The American Political Science Association announced that their next annual meeting would feature multiple sessions examining the intersection of legal scholarship and political practice, using the Posner-Crockett hearing as a central case study. Law. Review editors at major universities began commissioning articles about the strategic use of judicial precedent in political advocacy. Several prominent legal scholars announced they were beginning research projects examining how politicians could more effectively engage with judicial decisions through scholarship rather than rhetoric. The hearing had opened up new academic territory at the intersection of law and politics. Perhaps most significantly, the hearing demonstrated that substantive intellectual discourse was still possible in American politics, even across generational and ideological divides. In an era when most political confrontations devolved into personal attacks and partisan talking points, Crockett and Posner had shown that disagreements could be resolved through careful analysis of legal precedent and constitutional principle. Impact on legal education was immediate and profound. Within weeks of the hearing, constitutional law professors across the country were incorporating video clips and transcripts into their curricula. Students were assigned to analyze Crockett's argument strategy and identify the techniques she used to turn Posner's own philosophy into support for her position. Mock trial competitions began featuring scenarios based on the hearing, with law students competing to replicate Crockett's strategic use of judicial precedent. Legal writing instructors used her preparation methods as examples of how to research and organize complex constitutional arguments. The hearing became a teaching tool that would influence legal education for years to come. Judge Posner himself seemed genuinely affected by the experience. In interviews conducted in the days following the hearing, he spoke repeatedly about how Crockett's analysis had helped him see connections in his own work that he had previously missed. She showed me how my scattered thoughts across decades of writing actually formed a more coherent philosophy than I had realized, he told one legal publication. The hearing also had practical political implications. Congressional leaders who had previously dismissed Crockett as too confrontational began viewing her as a valuable strategic asset. Her ability to engage with complex legal arguments while maintaining her political principles made her an attractive figure for leadership positions. Legal advocacy organizations began studying Crockett's approach as a model for how to engage with hostile judicial environments. Civil rights lawyers noted that her strategy of using judges' own precedents and philosophies against them could be replicated in other contexts. The impact on judicial-legislative relations was immediate and significant. Other judges began expressing interest in more direct dialogue with thoughtful legislators. Several federal judges issued statements suggesting that the kind of engagement demonstrated in the Posner-Crockett hearing could help bridge the growing divide between judicial and political institutions. But perhaps the most important long-term effect was what the hearing revealed about the possibility for substantive political discourse in an era of soundbite politics. Crockett's weeks of careful preparation and sophisticated legal analysis stood in stark contrast to the typical political approach of attacking opponents without engaging their actual arguments. Political scientists began studying the hearing as an example of how elected officials could elevate public discourse by doing the hard work of mastering complex subjects. The contrast between Crockett's approach and typical political rhetoric was so stark that it sparked conversations about whether American politics could return to a more substantive, intellectual foundation. The story continued to develop in the weeks following the hearing. Law review articles began appearing analyzing Crockett's legal strategy and its implications for constitutional dialogue. Political magazines profiled her rise from civil rights lawyer to congressional star. Legal conferences featured panels discussing the hearing and its significance for American governance. Most remarkably, Judge Posner announced that he was beginning work on a new book about the relationship between judicial and legislative branches, with a foreword acknowledging Crockett's contribution to his thinking. She reminded me that the best legal scholarship often comes from unexpected sources, he wrote in the announcement. The Jasmine Crockett who walked out of that federal courthouse was different from the one who had walked in. She had entered as a young Congresswoman facing questions about her constitutional understanding. She left as a nationally recognized legal mind who had earned the respect of one of America's most distinguished judges. The impact on judicial-legislative relations was immediate and significant. Other judges began expressing interest in more direct dialogue with thoughtful legislators. Several federal judges issued statements suggesting that the kind of engagement demonstrated in the Posner-Crockett hearing could help bridge the growing divide between judicial and political institutions. But perhaps the most important long-term effect was what the hearing revealed about the possibility for substantive political discourse in an era of soundbite politics. Crockett's weeks of careful preparation and sophisticated legal analysis stood in stark contrast to the typical political approach of attacking opponents without engaging their actual arguments. Political scientists began studying the hearing as an example of how elected officials could elevate public discourse by doing the hard work of mastering complex subjects. The contrast between Crockett's approach and typical political rhetoric was so stark that it sparked conversations about whether American politics could return to a more substantive, intellectual foundation. The story continued to develop in the weeks following the hearing. Law review articles began appearing analyzing Crockett's legal strategy and its implications for constitutional dialogue. Political magazines profiled her rise from civil rights lawyer to congressional star. Legal conferences featured panels discussing the hearing and its significance for American governance. Most remarkably, Judge Posner announced that he was beginning work on a new book about the relationship between judicial and legislative branches, with a foreword acknowledging Crockett's contribution to his thinking. She reminded me that the best legal scholarship often comes from unexpected sources, he wrote in the announcement. The Jasmine Crockett who walked out of that federal courthouse was different from the one who had walked in. She had entered as a young Congresswoman